Broadcast is now starting. All attendees are in listen-only mode.
Welcome to today's webinar, Update COVID-19 Labor and Employment Issues and Developments. I'm Anna Hobson from HR Simple and I will be moderating today. Today's presenter is Greg Grisham from Fisher Phillips. The presentation today will be about an hour long. If you have any questions, please submit them in the question box. If you need more COVID-19 resources or would like to watch more webinars, please go to hrsimple.com/events. You can also go to youtube.com/HRSimple to view past webinars. HR Simple provides federal and state-specific manuals. We make employment law easy. Our books are written by top labor attorneys. Vacation policies, employee documentation, and how to fill out the I-9 form are just a few of the topics the manuals cover. Today, you can use code COVIDWebinar30 for 30% off any purchase as a thank you for attending our webinar today. Now we'll take a little time to learn about Greg. Greg Grisham is of counsel in the Memphis office. He is currently a part of the Fisher Phillips COVID-19 task force. For 30 years, Greg has successfully counseled and represented employers in all areas of labor and employment law. He has successfully litigated hundreds of administrative charges, employment lawsuits, and arbitration demands on behalf of employers, including federal and state law claims. Greg also represents employers before the NLRB in unfair labor practice proceedings. Additionally, he represents employers in the enforcement of post-employment restrictive covenants such as non-compete, non-solicitation, and non-disclosure agreements and related trade secret litigation. So I am now going to pass things over to Greg so we can get started.
Good. All right, Anna, is the screen showing okay?
Yes, it looks good.
Okay. All righty. Well, listen, thanks everybody for attending today. I had the privilege back in May to present this webinar, and since that time we've had a number of developments, so I've gone back and tried to update it with the changes. So for those of you who didn't attend the last one, you know, I don't think anything has happened during my legal career that's had more of an impact on labor and employment law than COVID-19. It's really touched every area, you know, just all facets. Not only leaves of absence, but the ADA and all types of discrimination and you know, plant closing law, NLRB. So it runs the gamut, you know, OSHA safety issues. So what I tried to do here is just to provide a good overview of the issues, you know, that we're seeing a lot of that are happening around the country. We're fortunate to be a national firm with offices all over the country, and so we're able to keep up with trends around the country, you know, and I think that's, you know, that helps us better advise our clients. So hopefully this will give you all a good overview. If you have questions along the way, please share those. We'll do our best to answer those for you. So let's get started. Yeah, the Families First Coronavirus Response Act, you know, I don't think in my lifetime I've ever seen Congress pass a law any quicker than that. That was so quick, and the implementation was so quick. You know, you would give clients advice up one day, and then something would change, and it was really just a moving target. You know, things have settled down a little bit, although we're getting some updates. We have a court case we're going to talk about that's significant. But this is a very significant law. It's the first new piece of federal employment legislation in a while. But also I want to caution you too, some of the states have enacted, and actually some localities have enacted laws that also govern leaves of absence, paid leave, things like that are actually, provide greater rights, than the Families First Coronavirus Response Act. So for those of you who operate across the country, and I'm sure there are a lot of people, people that are in multiple states, be sure that you check with your state law and your local law to make sure there's not, something that you have to comply with. And we've seen a lot of that, with the shutdowns and reopenings that are going on. I know a lot of states, in some states, the governor's calling all the shots. In other states, you've got the localities are really active. So you've got a lot of legal layers you have to wade through, work through. So keep state and local laws in mind when you're thinking about COVID-19 and things that are also covered by the Families First Coronavirus Response Act. All right, so who does this apply to? Well, when I was preparing for the last program, I did a little research, and more than half of the employees in the United States are employed with companies that have 500 or fewer employees. So I think that was the starting point for Congress to at least have a cutoff point. So the law is going to apply to employers that have 500 or fewer than 500 employees. And this is going to include full-time and part-time employees within the U.S., D.C., or any territory. Now, one thing you need to keep in mind, a company can be considered a single employer rather than a separate, standalone segment of a company. If the joint employer test under the Fair Labor Standards Act, which has been updated in the last year with a new regulation, applies, or they meet the integrated employer test under the FMLA, which has been around for a while. So you could potentially, instead of having several separate entities, you could have a single employer. Now here, a single employer, potentially could take you over 500 employees, but be aware that this test is there just to, we're trying to figure out this 500 employee limit. Now, if you've got to have a collective bargaining agreement with the union, which fewer employers have today, that have better leave benefits, those of course have to be provided. And then state and local governments are also covered by this law. So this is the universe of people, entities that are covered. Now, one interesting thing here about this law, they provide a very expansive definition of healthcare provider or emergency responder, which were people that could be excluded. You didn't have to let them, take paid sick leave or emergency FMLA. And it even extended to entities that contracted with an entity that met the definition of a healthcare provider. We're going to talk about this case in more detail in a few minutes, but a case came out a couple of weeks ago, State of New York versus Department of Labor, out in the Southern District of New York, which said that that's an invalid designation because it goes well beyond what the statute entails or authority of the statute, and it also is way beyond the definition of healthcare provider in the FMLA. So we'll talk more about the case, but we've got a case out in the Southern District of New York, which I'm sure will be appealed by the Department of Labor to the Second Circuit, and we'll see how that plays out, but it is interesting to compare and contrast the FMLA definition of healthcare provider and the one in the statute. So we're advising our clients to be cautious, and because this case could only apply to New York, or it may be found to apply on a broader basis, and other courts could also adopt the ruling of the court. So this is a very, very significant area that we believe has been affected in the last month or so. Now, what about eligibility? Well, if you were laid off before April 1, which was the day it went into effect, you're not eligible, right? And those people had to file for unemployment benefits, which of course were, jazzed up with the CARES Act. And the statute, the regulations say that if it closes, the workplace closes, or the employee's laid off or furloughed on or after April 1, they could be entitled to the leave up to the time that they were furloughed or the facility closed. And once again, I know this case that I just mentioned, State of New York versus Department of Labor, that case said that that work availability is invalid. That it doesn't matter. There are three of those where work availability is mentioned, and emergency paid sick leave, and I think emergency FMLA, and the court said that's invalid. That if the employer, even if the employer is temporarily closed, if the employee gets fired, of course, or if the company goes out of business, it's certainly not going to apply there. But the court basically said the DOL went beyond their authority, in enacting at least those parts of the regulation. So we have some current issues with eligibility. Now, documentation, we all know documentation is important, not only to, memorialize the fact that you granted leave. It's also important under the CARES Act to be able to, justify or get paid back, for the paid leave. But anyway, it's important to have it. But another notation here with this decision, the court said that you can't require documentation as a prerequisite to granting leave. You can still require documentation, but you can't deny leave if you haven't received it. So, this is the holding in the case. Once again, we don't know how expansive this is going to be. This was in New York, but you still, certainly need to have documentation documenting the leave, and for all the reasons that I just stated. But just don't prohibit someone from taking the leave if they don't, have it there on the day that they, want to take off. Here's some specific documentation that's referenced in the regulations. Government quarantine isolation order. Those have loosened up somewhat, although there's always the danger that we'll go back to that. I think most states now are reopening. Tennessee, we're reopening, have a reopening plan, and we're sort of in place right now, just because we've had a bit of a spike in the last couple of months of coronavirus. But this is the basic documentation that you can require to help justify the leave, granting the leave. But of course, once again, as I said a while ago, don't not grant the leave because they don't have the documentation at that time, but insist that they provide it. So documentation remains very important, because people, as we all know, unfortunately, employees will tend to play the system, milk the system as much as they can. Not all do that, but documentation really helps with that. All right. Teleworking, if employees teleworking, they may take intermittent leave. Everybody now, I think, is in favor of teleworking. A lot of employers, there have been a lot of cases over the years where employees wanted to, I think they've called it telecommuting, and it's been called different things. Teleworking is the new word. People have asked for that as a reasonable accommodation, and so there's some cases. There are cases in the Sixth Circuit which covers Tennessee, Michigan, Ohio, and Kentucky that over the last several years that really addressed this and had some good detailed analysis of it. But I think we're going to see a lot more of that. It's going to be harder for employers to deny teleworking as a reasonable accommodation once they start bringing more people back. So if employees teleworking, they may take intermittent leave. If the employee is working on site, not teleworking, they may take intermittent leave to care for a child due to school child care closure. But the employee can't take it for other qualifying reasons. And the reason for that is, of course, if you're there in the workplace, if you're sick or suspected of being sick, the intermittent leave restriction there is just to limit exposure in the workplace, which even the court in the case we've been talking about said that was okay. But going back to the case, the court said that the regulations basically require that the employer and employee agree to intermittent leave before it can be taken. And the court in this Southern District of New York case said that employer consent, where intermittent leave is permissible, employer consent is not required. They said that the Department of Labor went too far in enacting that as a regulation. So that is at least that's the view of the court in the Southern District of New York. All right, let's talk about emergency. We've been sort of covering both emergency paid sick leave and the emergency FMLA, but let's just kind of go through these as a bit of a refresher. You've got, and this is in light of the things we've been talking about the new case, but these are just the regs in place, at least in most parts of the country. They haven't been enjoined by a court. So what are the qualifying reasons? Well, you've got a quarantine or isolation due to COVID-19. There's some limitations there that that are listed. If there's work to be done, if the employer is shut down, for example, they're a non-essential business. Under the regs, at least, they say that employees don't qualify because there's not work available. Employee advised by healthcare provider to self-quarantine. These are people that you don't want back in the workplace while they're recovering. If they have problems after this, for example, if they are sick and are one of those unfortunate folks that really has a bad case of COVID-19, they could qualify for traditional unpaid FMLA leave after they use the paid sick leave. The third category is the employee has symptoms of COVID-19 is seeking a diagnosis. This is somebody who's actually has some symptoms and is going to a healthcare provider to try to find out if they had it, which it's been hard to get it, in some places at least, appointments with healthcare providers, but actually it seems like, at least in our area around Memphis, it seems much easier to get an appointment for people, and the testing turnaround times are better than they were. So those are the first three reasons. Number four, the employee is caring for someone who's subject to an order of self-quarantine. This is broader than the normal FMLA and also the emergency FMLA. It doesn't have to be a child or family member. The regulations really talk in terms of it's somebody who you may have some type of duty to to take care of, or have a close relationship. It could be a neighbor, it could be someone else, but the regulations talk in terms of it being someone that you would have a close relationship, substantial relationship with. And this is going to be to employees who has to care for somebody. You may have a child or a spouse or parents or somebody who have to quarantine because they're vulnerable to COVID-19. So if you're subject to that, certainly you can qualify for mercy paid sick leave, but you can also potentially get FMLA, traditional FMLA. For example, if it's one of the categories of people that you care for, with the traditional FMLA, which would be your spouse, a parent, a child, son or daughter, you can extend it with that, but it's unpaid. This is one that's coming up a lot. Employees caring for a son or daughter if school or child care is closed or unavailable. This is really kind of an ongoing discussion that we're having at work. A lot of our clients have questions about it. But here the employee is qualified when they actually need to and actually are caring for their child and they can't telework. In a lot of situations you have, more than one person in the home that can take care of the child. You may have one parent may not work, or maybe they work at home. You may have an older child who's old enough to take care of the child or supervise the child. So this is an area that I haven't seen it litigated, but employers, I think, are starting. I think it's been abused, or at least to some extent. So I think employers are being a little bit more aggressive in requiring documentation. So once again, you don't actually need to care for the child if there's somebody else there that's able to do it. Now what about pay, compensation? Well, this little chart here, this PowerPoint sets out what the compensation is. You got 1, 2, and 3 reasons for leave. They get the regular rate of minimum wage, and the 4, 5, and 6, you get 2/3 of your regular rate. You've got caps on that, $5.10 a day, $51.10 in the aggregate for 1, 2, and 3, and then $200 a day or $2,000 in the aggregate for 4, 5, and 6. And the thing about the mercy paid sick leave is you've got to provide it in addition to existing leave policies. And the employee, you can't dictate which one the employee uses. The employee has a right to choose which one comes first. So, this is sort of a bit of a revolutionary law, at least in federal law, in terms of paying someone for being off. And I think probably we're going to see some legislation in the next Congress where, some of this is going to be made, I think, permanent, some aspect of it, because it is very popular with employees. It has become popular. So you've got the compensation piece of it that you've got to look at. So let's look at emergency FMLA. Both of these, we have to understand that both of these, mercy paid sick leave and emergency FMLA, run from April 1, 2020 until December 31, 2020. It expires at the end of the year. So unless Congress acts to carry it over, both of these laws will expire or sunset then. So what about emergency FMLA? Well, it's different, of course, from the normal FMLA because most of it's paid. The first 10 days are unpaid. Of course, the employee can decide to substitute some type of paid leave. It could be paid sick leave if they qualify for that, or some other leave. Once again, you can't require substitution at that stage in the first 10 days. And then once you get past the first 10 days, you get 2/3 of your regular rate. And employers can't allow You may allow your employees to supplement, other accrued leave up to what they make. Of course, you can't get your tax credit from the government based on, the other third that comes from, some other paid leave program that you offer. And you can also require employees to use available paid time off concurrently. But if the employee's not sick, and this is true with FMLA, you can't force them to use medical or sick leave. Once again, we have caps, 200 a day, 10,000 in the aggregate. And we're seeing, I'm seeing a lot of intermittent use of this, which you've got some parents can stay home, 4 days a week or 3 days a week, and the other parent wants to stay home 2 days a week. And a lot of the schools, of course, are full-time online. They're not opening up, and some open up to some extent. They'll let the kids come in a couple of days or 3 days. So it's sort of a mess around the country now, but we are seeing a lot of intermittent leave use by in the emergency FMLA area. Now, restoration rights. One thing that's traditionally are the FMLA that is pretty tough is it's pretty strict on reinstating employees when they come back to the same job. The courts made this clear early on after the FMLA was passed. I've seen employers, lose cases where they brought someone back and put them on a different shift. It's got to be pretty close. However, a lot of people lost their job. Probably most people lost their job beginning in the spring because of the COVID-19 related shutdowns. They lost their job, and under traditional FMLA restoration rights, if the employee would have, their job would have ended anyway, you don't have to restore them to their job. I've had clients with employees that they discovered after they'd gone on FMLA leave that they're did something wrong, violated some rules, or maybe had an investigation going on. So if there's just cause to fire the employee, obviously they don't have any special protection if they violate your rules like that. But of course, you're asking for trouble anytime you fire somebody when they're on FMLA leave. But typically, if you have a widespread reduction in force, which is what you had here with the COVID-19 shutdowns, that's going to be a good reason. Now, you've got some special rules that apply if you have fewer than 25 employees, and you can read along here. Basically, there's some things the employer has to do, things that have to exist, and you've also got to make some reasonable efforts to restore the employee to an equivalent position. And also, it kind of goes on for a year there. You got to make reasonable efforts to let the employee know if a equivalent position comes available within a year of those two events listed in the PowerPoint. So restoration rights are pretty tough, pretty high standard to meet. But if you've got a reduction in force where someone's job is going to be eliminated, you're not certainly doing it to try to eliminate someone's position because they took FMLA leave, that's going to be a good defense to it. Now, I've had cases where that's happened, and I've had a case, several cases over the years where someone is sued, claiming the employer interfered with their FMLA rights and retaliated by making them part of the termination, part of the reduction in force. And those cases typically don't go very far, but be aware that they can come. Mercy FMLA and other leave, the leave runs concurrently. You get 12 weeks. You get really 80 hours of the Mercy paid sick leave, and then 10 weeks of or actually 12 weeks of the Mercy FMLA. First 2 weeks are not paid. Now, one thing that's important to know that the Coronavirus Response Act doesn't give you more than 12 weeks of FMLA totally. the emergency FMLA is just another basis on which to use the 12 weeks that you have. And I'm not really discussing here the service member, the extra time that service member caregiver issues that come up, but just for traditional FMLA. So if you've used, for example, tomorrow if somebody comes up and says, hey, I want to use emergency FMLA leave, if they've already used it up, either traditionally or through the emergency, then, they don't have any more. So they get 12 weeks running from April 1 to December 31. And you may have, as an employer, you may have a new FMLA year that you use, depending on what kind of year that you use, but it doesn't matter if it falls within 2 periods. You get 80 hours of the paid sick leave and the 12 weeks of FMLA total. And that's going to be it. Now, we've had some recent guidance issued by DOL. This is very recent. This came out in July. I wanted to bring this to your attention. DOL wanted to make clear that employers can make changes to their paid leave policies, as long as you're doing it, if you're doing it for economic reasons. You're not doing it for some illegal purpose, which most employers, all the employers that I've been involved with in the past, when they've changed that, it's all been for legitimate reasons. State law may have some additional restrictions that you need to be aware of, and that's why I've said, be familiar with your state law, and also local law in some states have these restrictions. Also, this is a good clarification. Telemedicine visits are considered in-person visits for determining whether someone has a serious health condition. Also, electronic signatures are sufficient, but to qualify the telemedicine visit as an in-person visit, you've got to have an examination, evaluation, treatment. You got to have video conference, and it's got to be something permitted and accepted by state licensing authorities, which I think pretty much all the states have okayed telemedicine. It's amazing to me, and talking to some doctors I know. My daughter's a doctor, oldest daughter's a doctor, and you've got a lot of doctors now that people are afraid to go in, and they're just, they're doing a lot of the telemedicine, which, it's good to have some option there. If you're afraid to come in, make sure people at least talk to a doctor. So that's important. Also, an employer may require a negative COVID-19 test before you let an employee who's out on a non-COVID related leave return, as long as you have the same rule for everybody. Now, CDC, we'll talk about that, is relaxed the standards somewhat in terms of their recommendations. For a while there, the turnaround testing was taking longer, and it was difficult to get doctor's appointments. I think that's improved in a lot of places. But I think, from an employer's perspective, it's great to have require a negative COVID-19 test before somebody comes in, because it's so easily spread, to give you some peace of mind. Here's some additional DOL guidance, and these are in the Q&As that DOL published. One thing that you can do, if somebody comes back from a self-quarantine and possibly they're, they may be susceptible of maybe in a category where they're, get more easily ill from COVID-19 or more seriously ill, or you're concerned about, spreading, spread or potential spread, you can move them temporarily to a position having less contact with coworkers or really the public, or you can require that they telework. So this is really sort of a temporary view, I think, of the restoration rules under the FMLA. once again, you don't get if you return to work from a furlough, you don't get an additional 80 hours. Basically, people get 80 hours period. If somebody uses 40 hours, which is a week, if they have 40 hours left. So even if you change employers, you don't get an extra 80 hours. It's just 80 hours, is your entitlement. Yeah, and it's also illegal, and I think probably everybody knows this. You can't refuse to return someone to work after furlough because you think they might want to take, paid sick leave or emergency FMLA, because this would be retaliation. And that would also apply, for example, if you had somebody who, because there's a specific FMLA reg on it, if you had somebody who, works there and they say, well, hey, I need to stay home with my child 1 or 2 days a week, trying to change their schedule so that they don't take it or whatever. So you can run afoul of, run into retaliation or interference claims if you're taking action to try to discourage somebody from using their leave. The courts very early on viewed FMLA entitlement as an entitlement, where if somebody met the qualifications, they should get it. And I think this is certainly the way DOL and courts are viewing the emergency paid sick leave and the emergency FMLA. Here's the ruling we've been talking about. I just thought it would be nice to kind of go over it in its entirety, the key rulings here, because we've kind of talked about it piecemeal. But the ruling, in sum, the court struck down the definition of healthcare provider, and it leaves only the FMLA-based definition of a healthcare provider to identify which employees may be exempted. Because, as I mentioned, there's some employees that are going to be exempted, first response healthcare employees. So with a more narrow definition, at least for this case applies, you're not going to have nearly as big a group of people who are going to be eligible to be exempted from the rules. Court also struck down the work availability requirements, which apply to 3 of the 6 qualifying reasons for paid sick leave, and also the 1 qualifying reason for emergency FMLA. So the court said you can't deny someone benefits just because of the work availability requirement. So it struck that requirement down. Also, you got this intermittent leave rule that we talked about, consent for intermittent leave. Once again, intermittent leave, permissible intermittent leave is pretty limited. Really favors teleworking employees. For employees on site, the only one that really applies is the staying home with a child provision. But the court struck down that rule, and also once again struck down the regulations that require employees provide documentation that supports their request for leave prior to the leave starting. So you have this ruling. New York's in the Second Circuit. I suspect the Department of Labor will appeal. Maybe go to the Supreme Court. The statute may expire before the case gets heard by the Second Circuit, since it's going to sunset. But the question remains, how far does this, case apply? Does it invalidate regulations across the country? I've heard arguments on both sides that, if they didn't enact the regulation properly, that, it's going to invalidate all over the country. Some people say no, but it's important to know about this case. And, a lot of employers may want to, follow the guidance of the court and start adopting these practices or discontinuing these things that the court, said were violative or said were not valid. And certainly you should do that if you're in New York or, in the jurisdiction that would be covered by this ruling. So that's a pretty significant occurrence. Also wanted to add this as like an update. to the webinar I did back in May, mandated state local face covering rules. I suspect probably everybody who's tuning into the webinar lives in a place or close to a place that has a mask or face covering rule. Where I am in Memphis has an ordinance, a face covering ordinance, and Shelby County, which is the county Memphis is in, also has one. So all of us in Memphis are, wearing masks unless we're in our office. I'm presenting this webinar from my office. Unfortunately, I don't have to wear a mask, but everybody's doing it. You can take them off when you go in restaurants, but wanted to add this just to make people aware. 34 states now mandate face covering, and a lot of these mandates are pretty similar. It's basically if you're out in public and you can't social distance, you're in some public place, you need to wear a mask, which I think makes good sense. And you got, of course, exclusions. Usually the exclusions are for kids children between a certain age. If you've got people that have asthma, they have difficulty breathing, or where communication is important. There's a good ARP website that I have listed in the PowerPoint that gives you the list of all the states and the mask mandates. So that's very interesting to look at. If you go to that link, you can get that. So you got 34 states. Some states, our governor in Tennessee, we developed something called I think it's called the pledge, basically, where it was recommended that all this happened, but he didn't want to make it mandatory. But as we'll see in a minute, other places in the state have done it, and this is true really across the country in a lot of states. For example, in Tennessee, once again, we don't have a mandatory order. You got at least 6 counties that have these orders, and these are in the major cities. Nashville, Chattanooga, Knoxville, Memphis, and also some of the smaller cities, Bristol, Jackson, and so they're all very similar. What I decided to do is I wrote an article for the Memphis Business Journal back a couple of weeks ago on the Memphis mask ordinance, and so I thought I would just use this as an example because it's very similar to a lot of the ordinances you're seeing. It requires people to wear masks when they're outside their home or where they reside. And it makes a distinction, has essential and non-essential businesses, but it really applies to both. And you got, special rules for healthcare operations, but it sets out a series of situations where people have to wear, employers have to require their employees to wear it. And we'll look at that list, which is not dissimilar from other lists around the country. Of course, interacting where you're working and you're having to deal with members of the public. We see that in restaurants, really anywhere we go, whether it's a governmental place or a retail store. Really any space visited by members of the public, grocery store. We're going in grocery stores and everybody has a mask on, which is a good idea. Waiting rooms, pretty much any place where the public gathers. Of course, where food's prepared or packaged, those kinds of places. Any kind of enclosed area where other people are present. Of course, this excludes members of your family. And also the Memphis ordinance, you've got to post signs and take other action to basically tell people, look, you can't, if it's a business establishment, you can't, come in here unless you have a mask on. And pretty much all employers have done that. All business owners have done that. And I haven't really heard or seen much of a problem. There are sanctions related to non-compliance potentially, which are fines and things like that. But anyway, those are the situations where you have to do it. Once again, exceptions. If you're in your personal office, you don't have to do it unless you've got people regularly coming into your office. If you're out working somewhere, you don't have an office, but you have a workspace and there's nobody there, or people aren't around you. If people start coming around and start visiting, you've got to put your mask on. And of course, you've got the exception for children, people in restaurants and bars. In Memphis, Shelby County, you can go wear your mask into a restaurant. Then when you sit down, you can take it off. And I think that's true pretty much everywhere. And of course, with people that have medical conditions. So that's a quick look at the Memphis ordinance, which is pretty similar to other ordinances around the country. Workplace safety, you got the general duty clause for OSHA. There's not a special clause for COVID-19, just the general duty clause is going to apply, and that certainly requires you to take steps to keep the workplace free from recognizable hazards. And of course, COVID-19 is something that employers are trying to reduce infections and adopt other practices to minimize infections in the workplace. Under OSHA, employees can refuse to work, but only when there's a realistic threat. Examples given: if you've got a medical person working in a hospital that doesn't have PPE, I certainly wouldn't want to work, and that would be a reason not to. But just because you're having to work around other people and the public, while COVID-19 is going on, that's not enough. So under the OSHA standard, the right to refuse is protected if, and there are 4 categories that you look at, and these are all go together. All of them have to be met. So and this is often not met because employers typically do the right thing. If they see something that is dangerous, they'll take action. And most employers aren't going to just ignore something. But anyway, those are the 4 hoops that the employee has to jump through to refuse to work. Of course, wearing masks is strongly encouraged, and it's required in a lot of places. We've talked about that. Employers not only should not refuse an employee's request to wear a mask, they should, it's a good practice to establish mask wearing, is required unless there's an exception for somebody, if they're out, in common spaces or around other people, if they're in the office. And also you can require employees to wear a mask. OSHA says if you require it, you should pay for it or provide it. And it says employers should comply with the PPE standard. So what else do we have from OSHA? Well, this is something newly added from the last webinar. Recording. Employers are required to record COVID-19 cases if they are work-related on the 300 log. And the criteria is it's a confirmed case, work-related, and the general recording criteria apply. So those are the 4 things you look at. There's a big, of course, issue right now. There are a lot of employees that are trying to get workers' comp for COVID-19 infections. Some states have made it easier for people who are first responders or medical people to do it, but ordinarily it's going to be difficult, I think, unless somebody's working in a healthcare setting or environment where they're having to have a lot of face-to-face with members of the public to make a good case for work comp. But I think you're going to see a lot of effort made to do it and a lot of pushback. You have to make a reasonable good faith inquiry to determine whether it's a confirmed case or not, or because of something to do with the workplace. If you decide that it's not, the exposure of the positive test was not more likely than not caused by the workplace, something in the workplace, you don't have to document it on the log 300, but you should have documentation showing what steps you took to make that determination, in case something comes up in the future. All right, plans for employees who test positive have been exposed to COVID-19. Well, the current, the newer updated CDC advice, and this is because of the strain on the healthcare system, are advising that employers not require employees to go to a healthcare provider and get clearance before returning to work. But of course, I think we can all agree that having the doctor's okay or having a negative test, it's going to be something that is very desirable to have. So employers have to make their own decisions on that. But I think because of the fact that the testing system was overwhelmed for a while and there were shortages of materials, I think they did that, but I think it has improved quite a bit. So anyway, these are the new guidelines that they suggest. They're less burdensome, than the old guidelines. I think they've just sort of increasingly become less burdensome. A lot of people have COVID-19. They don't have symptoms. I've had some family members that have had it. But if you're positive, for example, no symptoms, 10 days have passed after the test, you can, return to work, at least under the CDC guidelines. And you've got, similar situation here for positive test symptoms. These are relaxed. 10 days have passed since the onset of symptoms, and at least 24 hours have passed since the resolution of fever without taking Tylenol or whatever, and other symptoms have improved. So these are, much relaxed standards. Exposure, if you're exposed and don't have it, the guidance is still 14 days after last exposure. You don't have a positive test or symptoms, which is the self-quarantine period, that they've kind of stuck with that. There's also been relaxed guidelines for critical infrastructure employees because, they're out there on the front lines, involved in trying to keep things going. These would be things like the workers covered by this would be like law enforcement, call center employees, public and private hazardous material responders, workers and contractors in food and agricultural, critical manufacturing, transportation. There are a number of areas here that are considered to be critical. And for this group of people, at least, if they've been potentially exposed, they relaxed the standards as long as they're asymptomatic and you take some additional precautions, which are listed here. There are 5 things that they require you to do, which is good to make sure that they don't develop it, and lets them still work in the workplace. So these are, I have some employers that fall within this that just prefer not for them to be in the workplace if they're exposed, and that's certainly the safest way to handle it. But you don't have to under these guidelines. In terms of just exposure, you want to treat all suspected cases as a confirmed case. Once again, it's good to require, ideally, it's good to require employees to remain home, until they're cleared. But, and now I think it's easier, at least in most places, to go get clearance, go get an appointment. But if not, have them remain at home for at least 14 days after the last exposure. You also, in terms of people who work in close proximity with people who, who've been exposed or who had COVID-19, in close proximity, once again, is considered within 6 feet, and prolonged period of time is 10 or more minutes. If you're 5 feet away from somebody, for 10 seconds and say hello to them, that's not going to meet the definition. But anyway, these are you certainly want to be proactive and cautious. And if you identify people like this, send them home for 14 days and have them self-monitor to make sure that they don't develop, further symptoms or get sicker. So EOC guidance, haven't seen really any changes in that in the last couple of months. Once again, EOC considers COVID-19 a direct threat, which gives employers a lot more leeway in what they do. Direct threat is really usually a case-by-case concept that you apply to individual employees. But here they're considering COVID a direct threat, so it gives the employer broader rights. So can you screen applicants? Yeah, you can after making a conditional job offer, as long as you do it for all employees in the same job. You can, of course, make pre-offer medical inquiries. You've got to be cautious about that. That's just a basic ADA rule. Certainly, if you've got somebody, screening, I think everybody now screens people coming into the office. But if you should do that if you're not doing it, and screen for temperature, and and you can question if people have been in contact with anyone that has COVID-19 or has symptoms. Don't let them in. Don't let them enter your premises if they do. You got to keep, have a gatekeeping function there, and the EOC says that's perfectly fine to do. You can ask employees questions if they're reporting they're feeling ill at work or calling sick. You can ask them, if they have any of the symptoms related to COVID-19, such as fever, chills, cough, shortness of breath, sore throat. That's legitimate to do that. You certainly want to, a lot of employers, I think, are taking the temperature. A lot of companies are doing that. Most companies, I think. So you want to make sure the person doing it knows how to do it and assess results. And once again, it's 100.4 Fahrenheit or greater for COVID-19. And if you have people waiting to get in, have them, don't have them close together, have them social distance while you're going through the process. One thing that comes, that's coming up some is where do you have to pay people for, standing in line to get checked out? There's some cases that would say you don't have to compensate for that. That was similar to a Supreme Court case a couple of years ago. This is under the Fair Labor Standards Act, but some states, may have a different position. So that's an issue that's coming up some. And you have some best practices suggested when you, and how to go about taking the temperature. And you certainly want people to, leave the premises if they do have a fever, if they become ill. You want to, people need to be aware that they should let their supervisor or someone know if they become ill during the day, so you can deal with that. And also the big thing is confidentiality. Taking their temperature and asking them questions, those are confidential. It's confidential medical information, which is protected under the ADA. So be sure that any documentation related to that is going to go into the medical file, not their personnel file. And this slide here, this Q&A from EOC guidance talks about you don't have to have a separate COVID-19 file, but things like notes of employee statements and anything that has information related to it, needs to go in a confidential file, the overall confidential file. And the EOC will cite you if they come and do an on-site investigation and request records, and there's medical information in the personnel file. You can certainly withdraw offers and postpone start dates. EOC is okay with that due to the COVID-19 pandemic. What about reporting rehires to unemployment agencies? States or federal law requires the rehire reporting for people who have been separated for at least 60 days. You also have state laws that have different requirements. You know, time period in which to report rehiring an employee, typically 20 days from the date of hire. Some states have shorter periods where I think people have been abusing. A lot of people have not wanted to come back to work because of the more generous CARES Act, you know, supplement. Of course, now under President Reagan's executive order, that's gone down to 400, you know, assuming that some court doesn't enjoin it and say you can't do it. So that's reduced, but it's still you know, a nice incentive for people to stay home. So a lot of clients I deal with and the firm deals with, we have employees that you know, a lot of people who really don't want to come back to work. They would prefer to stay off. Yeah, if somebody refuses available work, if you call the employee back and they refuse to do it without good cause, you know, they consider it fraud to quit a job to obtain additional benefits. So there is a lot of that going on. You know, I know a lot of states have reenacted their work search requirements for unemployment. Those got put on hold during the early part of the pandemic. So some states are relaxing that. But the unemployment is going to continue to, I think, be an issue for people. So what about wage and hour issues? Well, you know, a lot of people got furloughed. A lot of people had their pay reduced or got reclassified. So when people come back to work, you know, you need to make sure that it's documented exactly what their new status is and they're aware of it. Everybody's clear on it. For example, if you have a new pay plan for people, you know, it needs to be, they need to receive a copy of it. You know, the appropriate documentation needs to occur. DOL has traditionally had hostility toward changing employees' pay frequently, and because, you know, some employers have paid a salary to people who didn't have exempt duty. So, you know, keep that in mind. It's good not to change that that often. I think COVID-19, everybody understands that was necessary, but in terms of a practice, it's good not to do it. You know, you got to also take into consideration if you've started paying out some kind of bonuses or hazard payments during the pandemic. You need to make sure if a person's working overtime, you know, that's factored into the regular rates. You properly pay them overtime. You also want to make sure that people who are working remotely properly enter their time where they're not in the workplace and go through the normal processes. Here's a recent DOL wage and hour guidance, similar to the guidance we talked about earlier under the Families First Coronavirus Response Act. DOL makes it clear that all hours teleworked are compensable for non-exempt employees, and this would include hours that they work that they weren't, you know, authorized to work. That's why it's important for employers for non-exempt employees to have clear understanding of their hours of work and to get approval for them to work overtime. And you should also, for people who are working remotely, you know, make sure they still review their time records before their numbers go to payroll for a check to be issued, to give them a chance to pick up any errors that are there. They're also relaxing the continuous workday standard, which is good. They recognize that people who are working at home, they may have children there who are going to school, you know, doing the online stuff. So they say it's fine for employers and employees to agree to have, for example, somebody to work 2.5 hours and be off for an hour, hour and a half, and, you know, have them work, you know, 8 hours, you know, with breaks, but, you know, you can space it out, but you have to keep up with the time, and, you know, you don't want to abuse it, but that benefits the employee. Employees like that. Once again, further guidance exempt employees may perform non-exempt duties during an emergency, which is COVID-19 qualifies without losing their exemption. Of course, you don't want that to happen too often because you can have problems in normal times when that happens. You can reduce salaried employee salaries, but you got to make sure they make at least the minimum, which is $684 a week. And you can't make the reduction based on the quality or quantity of their work. If it's just a general reduction due to economic conditions, then that's going to be fine. There's no obligation to provide hazard pay. That is true if people work in a hazardous job, and are exposed to COVID-19. But once again, as I mentioned a second ago, make sure that's included in the regular rate. If you pay hazard pay or some other kind of bonus, unless it's a discretionary bonus. Final walk through this. I think our time. I'm over my time, but we're getting over my time. But National Labor Relations Act considerations. Most private sector employers are going to be covered. It also applies to employers who don't have a union, because employees can engage in mutual aid and protection in what they call concerted activities under Section 7. You can also have single employees who are acting on behalf of a group take action. So that's why you got to be cautious. I think unionized employers are aware of this, but a lot of non-union employers don't realize, well, you get a work stoppage or something that may very well be covered by the Labor Act. What are some examples of protected activity? Well, you got people talking about, two or more employees talking about their pay or looking for ways to bump their pay up, talking about their supervisor, complaining about this or that. If it's related to the terms and conditions of employment, not just a personal gripe, and involves two or more employees, it very likely will be covered. Now, the board really was ahead of I guess, courts in dealing with social media. A lot of Facebook cases where employees would go online and say something bad about the employer or the workplace and would get fired, and then the board would say, well, you can't do that because that was protected activity. They even said in one case that liking a comment that somebody made was protected activity. So be aware of that. Be aware of social media. This can even play out on social media. Now, COVID-19 related safety concerns. This sort of falls right into the protected concerted activity area. So if you have employees that are coming to you complaining about their working conditions related to that, if it's a group, two or more, or one person claiming to act on a group, that's very well going to be protected activity. We've gotten threatened work stoppages. The teachers, a lot of the teachers around the country, maybe all of them are unionized. A lot of states make it illegal for teachers to strike, but there have been strikes over the last couple of years in, I think, West Virginia and Oklahoma. So you got potential for teacher strikes, and they're not covered by the National Labor Relations Act. But the workers at the Detroit nursing homes are planning a strike. I looked at that, and that's about, that's quite a number of employees. I think that's 1,600 employees who are complaining about staffing shortages, adequate PPP, and making more wages. So more labor stuff going on, work stoppages. Here's a list of some work stoppages that happened a few months earlier, really across the country, where people, a lot of workers, if their employer is very busy right now, in certain segments of the economy that are booming, they have a lot of leverage. So I think you're going to continue to see these work stoppages, as safety protests around the country continue. Now, there have been several recent NLRB advice memos. These are memos written by the General Counsel's office to regional directors, giving them advice on how to handle legal issues related to charges of unfair labor practice charges. So they don't have the force of law, but it gives you a lot of insight into how they're viewing this. And so they're there are actually 7, and these are online. You can go to the NLRB website under and get these and read them if you want to, because they're kind of lengthy. But anyway, the board is, seems to be, and the sum total of these, you could say that the board is really trying to, be sensitive to what employers are trying to do. They're trying to have a safe workplace, and so they're giving the employer the benefit of the doubt on a lot of things, which, you could expect them to, sort of given what's going on. But and pretty much all of them are, all 7 of these are pro-employer rulings. The current board, of course, is more pro-employer, much more pro-employer, or is pro-employer. The last administration wasn't. Significant. We have a litigation tracker on our website, and this is up to date as of before the webinar started. 516 total complaints. You got California is, of course, the hot spot. Florida, New Jersey are second and third, and you've got, so we're seeing 2 days ago when I prepared the PowerPoint, I think it was 498, or maybe it was yesterday, the last day or so, it was 498. So now it's 516. So we've updated on real time, but you can see that the number of cases are increasing, and the biggest area is right now is remote work and leave conflicts. So, and I've got some examples here of cases. So these are just complaints that were filed. They're not really court rulings, just to give you some sense of the type of cases that are being filed. Most of these are termination type cases where people, lost their job along with a lot of other people, claiming it wasn't really due to the fact that the employer was was targeting them, because of some protected characteristic, as opposed to a general, desire to reduce work to save money because of lack of business. So you're seeing these kinds of cases, come up, and here's some examples. We don't really have, court decisions. It takes a while for cases to work through the system, but we've got a lot of suits that were filed. So anyway, I appreciate the opportunity to talk to you today, and happy to answer any questions that you have. I think I have I've got some, Anna, I see some questions here from members of the audience. Do you want me to go ahead and try to address those now?
Yes, if you have time, that would be great.
Okay. Yeah, does Family First Coronavirus cover pay when we require employees to be tested and quarantined after travel? That's a good question. I don't know the answer to that off the top of my head. I think probably so. I think it would could potentially fall under, because I think, states now, a lot of the states, if you go from one state to another international, require you to be quarantined for 14 days. So it very well could apply. I think you'd have to sort of find out a little bit more about it, but certainly potentially it will apply. Anna, the one question is, will the deck of slides be provided? I think that the attendees have that. Is that right?
Yes, that will go out this afternoon.
Okay. All right.
All of the questions are in the chat box.
Yeah, I'm just looking through it. Another question: employees that have symptoms will stay out of work by following the CDC guidelines, but haven't been tested and haven't gone to a doctor. How does an employee get documentation from them? Will they not be able to get tax credits in this case? Well, that's another good question. One a little beyond focus of the seminar, we have a group of attorneys that specialize in these triple P loans and also the CARES Act. But I think you've got to have some documentation. I mean, ideally they should go and get cleared. They could certainly go and go get tested before they go back or go get checked out. So I think it is good to really have some kind of documentation from a medical provider, and certainly documentation from the employee, specifying what happened. So yeah, I would say that they should go and provide some documentation when they come back. I think the CDC guidelines really are a bit relaxed. I think requiring documentation, you have to do it to support get the loan forgiven or whatever, but I think, have them go to the doctor and get some kind of documentation to bring it back or get a negative test. If a salary person is teleworking from home part-time while on quarantine, does the time they are not working during that day go against the Emergency Paid Sick Leave Act? So I would say if they're teleworking, but they can't work, a full day, then I would say that would go, it's due to, they can't telework, but a certain amount of the day, I would say that would count toward their emergency paid sick leave if they wanted to do it. They certainly have a right to, it's their right to request it. So I would, leave it up to them to decide how they want to do it. But yeah, I think if they're incapacitated or restrained from working because of anything to do with, COVID-19, certainly going to qualify. Are there exceptions for this if we allow employees' child to come to work with them in the event that school or daycare is closed? I would say probably it's not a good idea to let kids come in the workplace. I know some employers have done that, but it's the employee's right to request that kind of leave. You don't want to do anything that's going to, potentially bringing a child in the workplace is going to expose the child, to things going on there. If you have some policy to do it, certainly that's within your right. But I would really, discourage that. And typically, if the school, the way the rule applies, if the school or daycare is closed, that's going to implicate both emergency paid sick leave and the emergency FMLA. So, and you can't do anything to try to discourage people from doing it. So, and we don't really have any cases or any further guidance on that. But I think certainly you could. But if somebody requests to, take it, you certainly can't deny that if they're entitled to it. Yeah, is there a difference between EPSL and Families First Coronavirus Act? Or are they the same? Well, really, emergency paid sick leave and emergency FMLA were both enacted as part of the FFCRA. Okay, there's some things that they have in common, but there are also differences between the two laws. So it sort of opened up with some of the commonality there because there are some. But yeah, emergency paid sick leave and emergency FMLA are both considered part of that law. They were enacted in the same legislation. Slide 14 talks about the emergency FMLA. If the employee doesn't have any accrued paid leave or sick leave, what's the procedure? Yeah, I'm not exactly sure if you, yeah, I'm not exactly sure how to answer your question here, really understand it, but let's say that if somebody, needs emergency FMLA and for some reason they don't qualify for paid sick leave, or they don't have any accrued paid leave or sick time, basically the first 10 days, first 2 weeks of the emergency FMLA would be unpaid. And then you would, there'd be a gap there, and then you would, pick it up on week 3. You would start paying them, the requisite amount under the statute. I think that's how you would handle it. I think most of us kind of assume that people are going to have something the first 2 weeks. But, in your example, it sounds like you could have people who don't. So I think you could voluntarily pay someone if you wanted to. But I think you would just handle it that you're granting the leave, the emergency FMLA, but it's just going to be unpaid because they don't have any basis to fill in those 2 weeks. Yeah, here's another one. If I'm off work for option 1, so I use the 80 hours, am I able to use it again for another reason? No, you just get 80 hours, period. That's the grand total of what you get under the emergency paid sick leave. Another one, with emergency paid sick leave and an employee who is teleworking, can intermittently be used to supplement if employee can only work reduced hours each day due to caring for a family member awaiting COVID. All right, Win. Yeah, I mean, you can certainly, you can certainly let an employee use intermittent leave since they're teleworking, for any of the reasons, eligibility factors, if they can, for example, a lot of people can work part-time. They have a sick family member, but they can work on their computer, work telecommute for a while. So you could certainly, let them work 4 hours and use the emergency paid sick leave for 4 hours. That's the way I understand your question. So yeah, you can let people in that situation, the teleworking people, use it intermittently. What I do if the FFCRA leaves exhausted in school is the only offering digital learning? How do I make it fair for all? Well, this is sort of the way that I've looked at it. You can have situations maybe because a person has used traditional FMLA and they don't really have any time left, and it is, tough with these schools going and going online again, for the fall after doing it in the spring. What I've seen employers do for people that don't really have anything is to offer them some type of personal leave of absence, or if you've got people, you could have people, for example, who need to be off focused on their children, their children's schooling or taking care of them for some portion of the day, but they might be able to work, part of the day at least. So I think you could offer, maybe convert some full-time people to temporary part-time status, or maybe change their working hours, but be creative about it. I don't know what kind of business you're in, but I think you can do some creative things to keep people employed. I think the alternative is if they don't have any leave, I think you could, and your company doesn't have any like special leave you have in this situation that you grant, I think you could do a personal leave of absence, which would be unpaid. Of course, that would, be a financial burden to the employee. But I think you either rearrange their work schedule, employ them on a part-time basis, or just give them an unpaid leave of absence, personal leave of absence. I think those are the options there. What's the proper legal way to screen employees for COVID-19 when they're in the workplace in the morning? Well, I think most employers now are taking the employee's temperature with these scanner thermometers, which are quite fancy. You don't have to get next to the person, get right up to them. So I think temperature reading and that's really the best way to do it. Employees need to certainly be advised if they've have been exposed to COVID-19, they've been around in close contact, as defined by CDC. They need to report that to the employer. I don't know that you want to quiz people every day, but you certainly could do that. You could ask them if they've had any symptoms. You could ask them, 4 or 5 questions related to it. That's certainly proper under the EOC guidance. So I think it depends on how long you want to take to do it. But I think it's good to certainly at least take their temperatures. That's going to be valid. And also ask questions about whether they have any symptoms or they've been around anybody. I think those are really commonly asked now, not only by employers, but also if you go to the doctor or anywhere else in public. Regarding close proximity guidelines, is that with or without a mask? We have employees in the manufacturing that work 4 feet apart with a mask on. Well, if one of them comes down with COVID, but all exposure was masked, should we consider that close proximity? I think in that situation, the masks certainly help. If you can't, so it doesn't sound like you can social distance because of the work. I think technically speaking, if they're 4 feet apart from somebody, even with a mask on, for a long period of time, which I think if you're working in an environment like that, you're probably going to be around someone pretty close, a big part of the day. I think I would err on the side of caution and consider that close proximity. I think the masks do help. I don't know if where the science is on the mask. I know everybody has to do it, and it's a good idea, but I think I would certainly consider that. Someone else might disagree with me, but that would be how I would look at it. Will there be any federal or state legislation to limit liabilities to employers on COVID-19? Yes, there's already some states have already done it. I know Georgia has, Tennessee has. I've seen this pop up nearly on a daily basis. I think there's federal legislation now pending. They're trying to come together. So yeah, the answer is if there's a federal law, that will be across the country. But if they can't get together on that, it being an election year, I think you're going to see most states or majority of states have some type of limit on liability because it's pretty crushing what could happen. Regarding requiring employee temperatures in the office, we're supplying no-touch thermometer and requiring employees to take a temperature each day upon arrival to work on an honor system. If they would have a temperature above 104, we would require that they self-report to our HR staff. We put a log sheet out and ask everyone to check off. They took a temperature once a day. Is that log sheet considered HIPAA protected? I would say I don't know if HIPAA really maybe doesn't necessarily apply to your situation. I think it doesn't apply as much as people think it does, but it's certainly I think a confidential medical record. Having a log sheet with everybody's name on there, I don't know if I would do that, but you certainly can. I think it's going to be okay if it doesn't have. All you're saying is they had their temperature taken. It doesn't have any details about what their temperature was. But what do you do if somebody, you want to certainly don't want people to put information on there that goes beyond that. So yeah, I mean, I would be cautious about doing it. I don't think it violates HIPAA. I think it's certainly a potentially confidential medical record. Our COVID-19 related family leave policies required if the organization already offers more generous time off policies. I think the family leave, the paid sick leave, and the emergency FMLA are basically entitlements for employees. I mean, they're going to expire at the end of the year, but these are things for the employees to use, and employees have a right to decide what to use, for example, whether they want to use some more generous benefit or they want to use paid sick leave, but they're typically in addition, to other kinds of leave. So I would say, yes, you should have COVID-19 related family leave policies, both for the federal law and also any state laws in the jurisdictions you operate in. I would do that, absolutely. What is to come in lawsuits, legislation, trends? Well, the tracker that I showed you, we actually have that on our webpage, so it's interesting to look at. We update it every day. But yeah, I mean, I think you're just going to see probably a lot of wrongful termination suits. If people don't get called back to work who were laid off, I think you'll see some probably a lot of charges out of that. I already showed you some charges, some cases have been filed so far, challenging the termination. I think you're going to see, OSHA whistleblower type claims being made. They reported something dangerous in the workplace, and so I think you'll see more whistleblower cases, and those happen at both the OSHA level and also the state level. And I do think you're going to see legislation that's probably going to make this paid sick leave and emergency family leave, make them permanent or some variation permanent. And I think you'll also have the time periods extended, because once you have something like that, it's hard to get rid of it. I mean, it'll go away unless everybody agrees, but they're pretty popular programs. So I think you'll see that. And I think you'll see liability limitation statutes passed. So yeah, I think those are the main things I see coming down the pike. But you never know with the coronavirus situation we've lived through. Anything's possible. One person had a question: can an employer in South Carolina provide an employee telework or work in a remote isolated location while self-quarantining, no symptoms? Well, I would say if somebody can, I mean, South Carolina, of course, you're going to be covered by the paid sick leave rule and the emergency FMLA. Certainly, if a person's capable of working, there are a lot of people. I even had to self-quarantine for 14 days, and I worked every day. So unless you're really sick, I think the answer is yes. I can't imagine South Carolina. We have an office there, but I can't imagine that there's any, and I don't think state law could, override federal law anyway. So I think the answer is yes, that you can. Is a local government municipal utility able to apply for the tax credit for the emergency paid sick leave? I think the answer is they can, because it applies to them, but that's over my pay grade. I would have to defer to somebody in our office that deals with that aspect of it, because I've really stayed away from it. I break out in a rash when I think about taxes, because I didn't score great in law school in taking the tax course. Another one, apologies if asked already, any further insight on how the EOC will be requiring vaccinations when one comes out? I understand now that there's some guidance in the flu. Well, what the rule has been, and I think it will probably remain, employers, particularly employers in the healthcare setting where you're dealing with the public, you're dealing in healthcare, where if you develop the flu or something like that, or you're going to make other people sick and create a problem, it's called business necessity, work-related business necessity. And so I've seen cases where, for example, pharmacists, people who work in hospitals, they were against vaccines, refused to take it. I think the employers, in the cases I've seen where employees have been fired, the employer won because they were able to show it was work-related and consistent with business necessity. And I think if you do that, you're going to be okay. But in terms of a widespread thing, there's typically sort of a understanding that employers can encourage employees to get vaccinations but can't require them. So, we may see a further relaxation for EOC because of the coronavirus, because that vaccine is going to be rolled out. So you may see a change. So that remains to be seen. But typically right now, people can object on religious grounds, medical grounds, from taking a vaccine, but the employer can require it, depending on the right context, particularly in the healthcare environment or where public safety is involved. Listen, thanks. Those are all the questions. Anna, thanks for letting me present it again. And if anybody has any other questions, feel free to email them to Anna.
Thank you so much, Greg, for staying overtime. We really, really appreciate you for that.
It's my pleasure.
If you have any additional questions for Greg, please feel free to email me at anna@hrsimple.com so I can forward those to him. It's right up on the screen. And I also do have the SHRM code up on the screen so you can get your credit. So make sure to go ahead and copy that down. If you'd like to attend more COVID-19 webinars, please go to hrsimple.com/events. This will be posted up on our homepage later today. And I also will be sending out the slides and a recording of this webinar later today so you can follow along. All right, everyone. Thank you so much for your participation today and have a great rest of your week.